Friday afternoon. I think we can keep this meeting very short. And I apologize for sending out the documents at the last minute. I've been working on them the days leading up to this meeting. But in talking with co-chair Obold Eshelman, we thought it would be helpful if the group had very specific questions that we could address. And also that if the group had time to reflect on those questions, because some of the things we're dealing with, as you know, these statutes cross-reference each other, and some of the provisions in the draft proposed changes, and so you might want to be looking at the original version of the current version of the law while you're looking at the draft. So what I'd like to do this afternoon is tell you about the documents that Sandy sent to you this morning, and then talk about our process going forward. My goal is that this will help us wrestle down and identify exactly what the group needs to talk about, and some other things that we could probably go forward with just your written responses. So Sandy, if I can share my screen, do I have the screen?
Yeah, you should. I gave you capacity, yes.
Okay. So the first document I'm going to pull up is the annotated draft. You don't need to be able to read anything on your screen. I just want to show you what's there, and then you'll be able to look at that on your own time. I'm going to share the screen. Okay. So this is our second working draft. And thank you again to Jim and Jessica for preparing this draft. This is fantastic work that is laying the groundwork for what we will do and the bill that we will finalize. What I did in this version of it, the annotated version, is just go through and insert comments. And you can see them on the screen, and you don't need to, we're not going to go through all of them, and you don't need to look at them or read any of them right now. But what I tried to do was to put annotations on here that might help you as you're doing your own review of the bill. As you'll recall, not only did Jim and Jessica prepare the draft, but Jim also prepared a table of derivations. And so the table of derivations explains where the provisions of the draft came from. But so that it might be easier for you and you wouldn't have to flip back and forth between the table and the draft, in the annotated version at the beginning of every section is a little blue comment. And that blue comment just pastes in the derivation information from Jim's document, so that when you're looking at section 1 and maybe section 1A, you can see where that language is derived from. And in his derivations, Jim identifies whether something's new, whether it is changed from the statute that it's based on. So all of these blue comments are informational. So like I said, every section has a derivation comment at the front of it. And then at certain places throughout the draft, when I thought, oh, you might want to know or have ready access to a statute that's referred to in the draft, I went ahead and pasted the text of the statute into a comment. So if you're like, if you're looking at section 1A and wondering what is a violation described in ORS 153.008, here's ready access for you, and you can see that statute there. So hopefully that'll help you read through more smoothly, answer questions that might come up without you having to crack open the ORSs. So those are all the blue comments. They're informational. And then there's other categories of comments. There's green comments here. Those comments are just, they concern things like word choice or phrasing or consistency of word usage throughout the draft. So those are not high priority in any way. It's just things that as I was reading, I thought we'll want to put a little note here because maybe we want to make sure that we're always saying justice court instead of justice of the peace. So those are the green comments. The yellow comments are a little bit more substantive, but not critical. And so it'll raise questions about whether there's a difference between the section and the current law. So those are the yellow comments. And I've done this through section 30. So sections 1 through 30 have annotations like this. The annotations that I'd like you to pay particular attention to are ones that are in red, although look at all of them if you would like to. Please do. I mean, if you have the time, please do. But as we scroll through the draft, you'll see there'll be questions, these annotations in red. And these are the parts of the bill that I thought, well, this raises a question that we should get the group's input on. And these are the issues that at least appeared to me as the most important ones that we really needed to kind of wrestle down and decide what we were going, make a decision about what was going to go in the bill. And so there's red questions throughout the draft. Now I'm going to change documents here. And so all of those red questions, so you don't have to kind of hunt and peck your way through the bill. All of those red comments have been reduced to questions, which are in the memo. So the memo sets out down here, this part. It goes through the bill in order. There are not red comments on every section. So that's why question 1 here starts with section 4. And let's just take a look at that first one. So one thing to remember about the draft bill is that the first part of it concerns justice courts. And then the first part of that section contains general provisions about justice court appeals. So that'd be for both criminal and civil appeals. To the extent we can say there's a process that applies to both criminal and civil, that's in this first part of the bill. And in the bill, these are broken out. So you'll see, okay, I'm in the general provisions. You'll see when you move to the provisions about violations and misdemeanors. And then you'll see when you move to the provisions about civil. So these questions here at the beginning relate to the general provisions about justice courts. And so if we just look at question 1, it says this concerns section 4, which is about transfers at the outset of a case from your justice court to the circuit court, not appeals later down the road, just currently under the law. In misdemeanor cases, if you are in justice court, you have the option of transferring your case directly to the circuit court, not having litigated in the justice court at all. So that's what section 4 concerns. And it raises the question, 2 questions. 1, right now under current law, you cannot transfer a case from a justice court of record to a circuit court. You can transfer a case from a justice court that's not of record to the circuit court. So this raises the question, should it be the same for justice courts not of record and justice courts of record? That's a question. For these questions, these are things that the group should talk about. I'm not pointing us in one direction. I think the best thing we can do is identify the pros and cons of the answers to the questions. So that's just an example of a question that is raised by the draft. Another one is this section 4 B here. So currently under the law, the way that the statute is written for these transfers, the statute only mentions misdemeanors. You can also have a violation in a justice court. And so here's the question. Should violations like misdemeanors be transferable to circuit court? Maybe, maybe not. But if you have an opinion on it, it's something that we should have an answer to. So those are the types of questions that I drew from our draft, and then I've set them out here in this document. So what I propose, so we have them all the way through civil cases. And this is the justice court part of the bill. So what I propose and would like your thoughts on is that with the annotated bill and these specific questions, what if we individually take these questions, think about them, prepare written responses to the extent that you want to prepare written responses. And then if those are sent through Sandy to Krista and I, we can look at them, then we can compile your answers on these substantive issues. That will help us say, oh, well, look, there's no question about, everyone's in agreement on this issue. Then that is an issue that we can resolve through the written responses, and we don't need to talk about in the group, and that will save us some time. My thinking in presenting the questions to you in this way is, like I said, you'll probably want to have the time to look at the existing law, look at the draft, think of the specific question. Maybe you want to conduct your own research, maybe you want to talk to your colleagues, maybe you want to talk to your staff, especially those of you who are in the Justice and Municipal Courts, like, will this process work that we have in the draft? So this just gives you more time to consider the question, gather information, talk to other people, and write something up. So the idea would be, you take the questions today, would have about 2 weeks to get back to us. We would compile the information, and then we would be able to answer these questions at our next meeting, and we would repeat the process for the municipal courts, and then hopefully be done with our group in 2 meetings after this. So I'm going to stop sharing my screen here.
Justice Robert, Justice Duncan,
Yes,
question for you. I believe the memorandum, first of all, I think this is great. The amount of work you've done is fantastic, and really, it really captures the issues. Just as a technical matter, I wonder if we could be sent a version that we can actually open so that we can enter our answers right under where the question is posed in your memorandum.
yes, and that's really a question that Jessica may be able to help us with. This document that I worked with is, and maybe Sandy as well, as far as our technological abilities, because it would be great, would save us a compilation step if there was, like in Google Documents, you can have multiple people access a document and put all their comments in one. Is that an option, Jessica, with this type of document, or Sandy with something?
I'll ask Jessica first, and then we'll see.
Okay. We don't have that capability at Legislative Council, but that's not to say we can't do it.
So Justice Duncan, the one thing I can do is, if the document, any type of text form, through the US service, we can't use Google, but I can use the Microsoft equivalent, which actually works exactly the same. It's just through online Word, and I can make it accessible to anyone, whether you have an account or not. And I can just share that shared document, keep the settings that anyone will be able to edit it, and that might be a way to do it. It's actually the way that we built our very, very large statute in a different work group.
Okay. I think that would be fine. The only reason I'm pausing a little bit is I don't know if the form of the document that we have, the PDF, can be converted to a Word document. Can you do that? Do you think, well, Sandy,
I can, yeah.
You can.
I've done, Jessica, unless it has some very unusual settings, I should be able to figure it out.
If you need, so this is the original document was a PDF generated from our drafting software, which is quite old and odd. But if Justice Duncan has been able to at least leave comments, it seems like it should work just like a regular PDF. But let me know. I know that there's a way to convert our drafting software to PDF, and there is a way to do it to Word, though it has never worked for me. The problem is now it's all in PDF with all these comments, and we don't have a way of converting that then.
So I have full access to the Adobe suite through UO. So I'll see what I can do. I'm pretty confident I can figure it out.
commenting on the draft bill or on Justice Duncan's memo. I was thinking of commenting on the questions as posed in Justice Duncan's memo, which may simplify your task, Sandy.
That should be really easy because that is just the Word document.
And that one, I can just simply create a shared version, and that's exceptionally easy.
I wanted to add something really quick just for the sake of the people in the group. If you see the green highlighting in this document and the little red notation on page 6, that is just to indicate differences between this one and the first work draft. And that was based on kind of the first however many meetings where we reached consensus on those changes.
Mhm. So thoughts on that approach? That's good. Thumbs up, some nodding. Okay, okay. Yes, Heidi. I don't think we can hear you.
IT, I think you're on mute still if you were trying to talk. That's what I'm seeing on my screen at least. Oh, okay, no problem.
I just had a thought, as far as how it's going to be most easy to comment. It seems like the Word document will be particularly easy to compile comments on for the big questions. For the little questions, like the little wording issues, it would be nice to be able to just add things to the draft bill if people have comments on the little wording questions.
If people are able to access the Word, the draft bill, I think one thing that might be helpful is if, you can either reply to a comment that's already there, but if you want to add your own comment, just claim a color, and then we'll know all, your comments come in that color, and we'll recognize them as something new. Is Katie able to maybe send a question through?
Yeah,
chat?
in the chat, it said, would it be possible to have 3 weeks for response?
Oh, yeah. I think that would be fine. We do not have a next meeting scheduled yet. We had talked about March 10th. Is that right, Sandy?
Because we had to push this, sorry, I was muted for a second. We had to push this one back due to scheduling conflict. We don't have one scheduled now. I know we had discussed potentially March 10th, but I didn't have that set. I'm happy with the group here today. Whatever, if we could set a date, I could get that scheduled today.
Okay. If we were to do it 3 weeks, that would be into March 17th. 16th or 17th in there. Does that work for people?
It doesn't work for me, but
Okay.
it doesn't mean I couldn't make it available and accessible regardless.
That whole week doesn't work, Sandy, or
Just the end of the week, just the 16th, 17th range, 15th actually.
and the 15th is out?
Unfortunately, yes.
Okay.
No, actually, the 15th I could do it.
How does that work for folks? March 15th, Ides of March. Okay. So that'll give us a little bit more time.
Okay.
Heidi, does that work? Okay,
What time on the 15th?
If we do 1 o'clock, that would work for me. I have another meeting at 3.
It should work. I can't get my court calendar scheduled up right now, but normally 1 o'clock, I'm okay. We usually We're very civilized, Court. We start at 2 in the afternoon.
20 minutes.
Okay, well, if that sounds like a plan, we can go forward with that. What I will also try and do in the meantime is annotate the second part of the bill and put out the questions for the second part of the bill, which should be shorter. So if that sounds like a good idea, we'll go with that. Sandy, if you could loop in Melissa's replacement, who she emailed about earlier this week, that would be great.
Yep.
Okay.
I do think on the 15th, though, that all comments must be made in the form of a Shakespearean soliloquy. Friends, Romans, countrymen, I come to Betty Caesar not to praise him. You know,
Just on the 15th, which might end up in us rescheduling, all right. So anything else for the group? Krista?
So I'll get those documents. I will at least convert the Word document, just make sure I'm on the same page, to an easily shareable online version. I think the PDF, now talking through it, I think we should probably just, if folks are able to make comments on that the way it is now, I would keep that as is, because the way it was created, as Jessica says, is a protected form. If I take it out of that form, we might lose the comments, which would go against, so I think as long as everyone's able to manipulate that, that's fine. I also could share a different version, but I don't think it would be with all of the highlighting and comments the way it is right now.
The only catch with, like I was able to comment and only comment in red line. Those are the two things I could do on the document.
Okay.
If everybody saves a copy of it and starts commenting, then we're just going to have 6, 7 versions. With everyone's own comments, unless you can come up with a better solutions, Andy, so that we're accessing like a online.
Yeah, so one thing I'm certain I could do, if Jessica could just send me a clean version without the comments.
I could send that. So the original version that I sent back in October was password protected, and that's why you were only able to leave comments. And the whole reason for that is to prevent this from being dropped as a bill, basically, because this is exactly what our bill drafts look like. That's why there's the watermark on it. But I could potentially send you a clean copy that is not password protected, as long as we all promise not to try to drop this at the Senate or House desks this session.
Promise.
I think we all can stand by that one.
Okay, we're a small enough group. Okay, I could do that.
So let me work on that, and I will, Jessica, thank you, and I will send an email with certainly a shareable link to a new Word document, and then I'll do what I can with the PDF. I'll just play with a little bit, and hopefully it'll be one that we're easily able to comment on.
Okay. That sounds great.
And I'll get the meeting scheduled for the 15th at 1. I'll do that today.
Okay. And we'll look for the documents from you, Sandy, the shareable documents.
Yeah, I'm going to try to get that done today as well, if I can.
Great. Okay. If that sounds great, we'll just go ahead with that, and we'll be in communication with a reminder or two, and then we'll send out the consolidated comments before the next meeting. So you'll be hearing from Sandy a couple of times between now and March, just checking in and sending you the materials in advance of the meeting. Okay.
Perfect.
Great. Thank you all. Have a good rest of your day.